Hello, bonjour, Tenancy. I'm Claire from the Family Law Information Center. Welcome to our webinar on family violence. Before we begin, I want to touch on the issue of online safety. It is common for abusers to monitor phone and internet use. If you are concerned that someone may be monitoring your internet use, consider viewing this video or any other videos in our family law series from a safe device. This might be a computer at the public library or at a friend's house. If that is not an option, consider clearing your browser history after viewing. For instructions on how to clear your browser history, visit violencelink.ca. In this video, we will talk about what family violence is and how to identify it, safety precautions, where to find additional resources online and in the community, and the legal options to protect and assist people who are experiencing interpersonal or family violence. Family violence is conduct between family members that is violent or threatening or causes a family member to fear for their safety or the safety of another person. In the case of children, direct or indirect exposure to family violence is considered a form of violence in itself. Violence can also take the form of coercive or controlling behavior. Family violence can occur at the beginning of a relationship, during, and after the end of a relationship. If you are experiencing family violence, you are not alone. Family violence affects people of all genders, sexual orientations, and racial, economic, educational, religious, and cultural backgrounds. Often, when we think about abuse, the first thing that comes to mind is physical violence, things like hitting, kicking, or choking. But family violence can come in many different forms. In addition to physical abuse, family violence can include things like forced or non-consensual sexual activity, name-calling and insults, making threats, including threats to harm children or pets, isolating someone from friends and family, preventing someone from going to work or church or even leaving the house, withholding or stealing money, and stalking or harassment. These are common examples of abusive behaviors, but this is not a complete list. All forms of violence should be taken seriously. Experts often refer to abuse as being a cycle. Abusive behavior does not usually happen at the very beginning of the relationship, but eventually tensions begin to build. During the tension building phase, the partner being abused may feel like they are walking on eggshells, like everything they do is wrong. The abusive partner may be increasingly jealous or controlling. Eventually, these tensions build to a violent incident of physical, sexual, emotional, or psychological violence. After an abusive incident, there is often a period of reconciliation. The abuser may apologize and make promises to change. It is also common for abusers to downplay and make excuses for their violent behavior. This is usually followed by another period of calm, but eventually tensions start to build again and the cycle continues. The cycle often speeds up over the course of a relationship. Periods of calm become shorter and violent incidents occur more often and increase in severity. All family violence results in one family member exerting control over another, either in the moment or for a longer period of time. The term coercive controlling violence refers to a pattern of abusive behaviors that are used to dominate or control another family member in a more comprehensive or methodical way. This pattern involves a combination of different types of abuse. It may or may not involve physical violence. Examples of coercive and controlling behavior include the use of threats or intimidation to control a person's behavior, insults and humiliation, isolating a person from friends and family, stalking or excessive monitoring, and controlling finances. Even when coercive controlling behavior does not include physical violence, it is a very serious form of abusive behavior. Coercive control is often an indication that the abuse will escalate and could result in serious injury or even death. There are many cases of domestic homicide where there has been no history of physical violence, but there has been a history of coercive controlling violence. Through domestic violence death reviews and other research, experts have identified a series of risk factors. Research has shown that when risk factors are present, and especially when multiple risk factors are present, the likelihood of serious danger increases. Coercive and controlling violence is one risk factor. Other risk factors include if the perpetrator has a history of domestic violence or a history of violence outside the family, if they have depression or a prior history of suicide threats or suicide attempts, if they are unemployed, or if they are using drugs and alcohol excessively. Risk of serious harm also goes up when the intensity of abuse has recently increased, if the victim has recently indicated an intention to leave the relationship, and after the parties have separated. If you are experiencing family violence, you are not alone. There are people and services that can help. If you are in immediate danger and need assistance, call 911. To find out what non-emergency services are available in your area, contact 211 Saskatchewan by visiting abuse.sk.211.ca, calling or texting 211, or visiting pathssk.org and clicking Get Help Now at the top of the page. These services can help you connect with counseling, shelters, and other supports. They can also help with safety planning. Everyone who's experiencing family violence should have a safety plan for what to do if a situation becomes unsafe. Having a safety plan will help you know what you need to do and act quickly to keep yourself and your family safe. Some important elements of a safety plan are knowing where you will go, how you will get there, what to take with you, and who to contact for support in case of an emergency. It's a good idea to keep certain essential items such as clothing, medications, extra money, and important documents in a safe place that you can access quickly when you need to. If you have children, you should also help them come up with an age-appropriate safety plan. A child safety plan might outline how to call 911, who else they can call for help, and safe places for them to go in an emergency. For more information on how to make a safety plan, please visit publications.saskatchewan.ca and search for Domestic Violence Safety Plan to download a safety planning guide and fillable worksheet. Staff at domestic violence shelters and counseling centers can also help with safety planning. In addition to making a safety plan, you may wish to keep a record of the abuser's behavior. People who experience abuse often have difficulty recalling exactly what happened and when, but knowing these details may be important later, especially if you are making a report to police or making an application in court. It is important to keep documentation in a safe place where it cannot be found by the abuser. Here are some forms of documentation you can consider. Keeping a daily journal about what happened and how you feel. Saving or taking screenshots of abusive or harassing texts, emails, and voicemails. Taking pictures of injuries and damaged property, and keeping any relevant medical or dental records. You can call a trusted person, such as a counselor or family violence worker, after an abusive event. You can also contact police and tell them you want to make a statement. Depending on the nature of the abuse, the police may or may not charge the perpetrator, but having a record of previous instances of abuse will help police know how to respond in case of an emergency in the future. The victim of abuse is not responsible for laying charges. There are several laws in place designed to assist and protect people who are experiencing family violence. The type of order you could seek will depend on the urgency of the matter and what you are asking for. Some are meant to be used in urgent situations, but if you are in immediate danger, you should contact police before taking any other legal action. In urgent situations, you can apply for an Emergency Intervention Order, or EIO, under the Victims of Interpersonal Violence Act. An EIO is a court order that can include certain conditions and requirements, including an order that the suspected abuser not contact you or your family, an order that gives you the right to stay in your home without the abuser being there. It can direct a police officer to remove the abuser from the home, and it can direct a police officer to go with you or the abuser to supervise the removal of personal belongings from the home. The conditions in the order will vary according to the situation. You can apply for an EIO if you're the victim of interpersonal violence and you live with or have lived with the abuser in a family, spousal, or intimate relationship, if you have children together, if you're in an ongoing caregiving relationship, regardless of whether you have lived together or not. This includes spouses, common law spouses, same-sex partners, children, parents, siblings, and people living with caregivers. An emergency intervention order can be granted by a justice of the peace at any time of the day or night, and the person named is bound by the order as soon as they are given notice that the order exists. To get an EIO, you can contact police, victim services, or mobile crisis and tell them what has happened and why you fear for your safety. If legal requirements are met, they will help you apply to a justice of the peace. Once the order is made, it will be reviewed by a judge who will either confirm the order or decide that a hearing is necessary to decide whether the order should be confirmed. If an order is made and you want it to be changed, you must make an application to the Court of Queen's Bench. A peace bond is a court order made pursuant to the Criminal Code that requires the person named in the order to keep the peace and comply with certain conditions, such as not to contact you or not to go to your home. The conditions can stay in place for up to 1 year. A peace bond is not a criminal conviction, but if the person named breaks any of the conditions of the peace bond, they may be charged with a criminal offense. You can apply for a peace bond if you have reason to believe someone may harm you, a member of your family, or your property. You can apply for a peace bond by going to your local police station or RCMP detachment and swearing in information, which is a statement explaining your situation, your reasons for believing you are not safe, and why the person named in the peace bond may be a danger to you. It is a good idea to bring a written statement, as well as any other relevant documents, with you to the police station. If the police conclude that there is a reason to believe you or someone else may be in danger, they will create a peace bond and make a list of conditions. They will then contact the subject of the peace bond. If that person agrees with the conditions, the peace bond will be in place, and they will be bound by the conditions immediately. If the person does not agree, a court hearing may be scheduled. If there's a hearing, it is conducted by the Crown prosecutor, but both you and the person named in the peace bond must attend. The court will hear testimony from both sides and decide if the peace bond should be granted. If the peace bond is granted, it remains in place for the length of time ordered by the court, up to 12 months. After the peace bond expires, if you still fear for your safety, you can apply for a new peace bond using the same process. Victims' assistance orders are similar to emergency intervention orders, but they are made to be used in non-emergency situations. To get a victim's assistance order, the victim applies directly to the court. They can represent themselves or seek the assistance of a lawyer. People who are self-represented can contact the Family Law Information Center for guidance on how to apply. In a victim's assistance order, the court can order everything that can be ordered under an emergency intervention order. In addition, in a victim's assistance order, the court can order that the accused pay compensation for expenses such as the loss of earnings, medical and dental bills, and moving expenses that are a direct result of interpersonal violence. The court can order that either party have temporary possession of certain items, such as the vehicle, bank card, identification documents, passwords, and other personal effects. It can order the police accompany either the victim or the abuser to the home to collect belongings. It can prevent the accused from selling or damaging certain property. It can recommend that the accused receive counseling and require that the accused post a bond to ensure that they comply with the terms of any order. In addition to victims' assistance orders, the court can grant other orders under Saskatchewan's family law legislation. These orders would typically be applied for as part of a larger family law application, such as an application for divorce, a parenting order, or property division. Some orders that are frequently requested in situations involving family violence are an order that one person have exclusive possession of the family home, an order that one person not go into or near the family home, or the court can also order that a person not give away or sell any of the family property until there has been a decision about how the property will be divided. The court can order that a person not contact or harass the other person or their children, and depending on what parenting arrangement is in place, the court can order supervised parenting time or supervised exchange. Supervised parenting time means the time that the other parent spends with the child will be supervised. Supervised exchange means that there will be a third party present to help facilitate the exchange of the children. You can also ask for an order preventing removal of the child from a specific geographical location, which prohibits the other party from traveling with the child outside a specified area without the consent of the other parent or a new court order. Victims' assistance orders and other orders under family law legislation are obtained by making an application to the Court of Queen's Bench. You can make these applications with the assistance of a lawyer, or you can represent yourself. If you would like legal advice but can't afford to hire a lawyer, you can apply to Legal Aid or Pro Bono Saskatchewan. Another option is to consult a lawyer who provides unbundled services. Unbundled legal services means you hire a lawyer to do specific tasks and only pay for those tasks. You do other work that needs to be done yourself. A list of lawyers who offer these services is available on the Saskatchewan Legal Coaching and Unbundling website, www.sklcup.com. For more information, including information on how to represent yourself in court, you can contact the Family Law Information Center. Some other laws that may be helpful if you or someone you know is experiencing family violence are Clare's Law, the option to end a fixed-term tenancy, and the option to take interpersonal violence leave. Clare's Law is a law that allows police to disclose risk information related to someone's violent or abusive past to intimate partners whose safety may be threatened. Using Clare's Law, you can apply for risk information about your own partner, or if you're the parent, guardian, or otherwise have a close personal connection with someone who may be at risk, you can apply on their behalf. Regardless of who makes the application, the information will only be shared with the person at risk. To apply for risk information using Clare's Law, you can contact any police service in Saskatchewan. If you rent your home and you are living with someone who makes it unsafe for you to stay there, the Residential Tenancies Act allows you to apply for a certificate that will allow you to end your tenancy on 28 days notice with no penalty. If you want to end a tenancy early, the first step is to apply to Victim Services for a certificate confirming safety risk. To apply, you will need to provide Victim Services one of two things: a copy of a court order or bond that says the abuser should not contact you or communicate with you, or a professional person statement that confirms interpersonal violence has occurred. The professional person statement can be signed by a social worker, psychologist, duly qualified medical practitioner, registered nurse, registered psychiatric nurse, member of the RCMP or a police service, or an employee of an emergency transitional shelter or an agency that provides support for victims of interpersonal violence. After you apply, Victim Services will determine whether there is a risk if the tenancy continues, and if there is, they will give you a certificate confirming safety risk. Fill out a notice to the landlord to terminate a fixed-term tenancy for interpersonal violence and give that notice and the certificate to your landlord. For more information on ending a fixed-term tenancy and how to apply, visit saskatchewan.ca and search Interpersonal Violence Programs, or call Victim Services toll-free at 1-888-286-6664. Under the Saskatchewan Employment Act, employees in Saskatchewan can access 10 days per year of interpersonal violence leave. The leave can be used to access medical services or counseling, to relocate either permanently or temporarily, or seek legal or police assistance. The entitlement includes 5 days paid leave and 5 days unpaid leave. They do not have to be taken consecutively. And it can be accessed by speaking to your employer, who is required to keep the information confidential. If your employer requests it, you may be required to provide evidence about the type of services you are accessing while on leave. Remember, if you are experiencing family violence, help is available. Please consider reaching out to some of the resources mentioned in this presentation. If you are looking for more information about family law, it may be useful to watch other videos in this series. These videos have information on ending spousal relationships, parenting arrangements, child support, spousal support, dividing family property, and options for resolving disputes. Thank you.